Well, good morning, everyone. Thomas Montgomery here. It is a beautiful Tuesday morning, January 18th, 2022. We get together with our distribution partners most weekday mornings at this time, minute or so before 8 o'clock Central. Each day we have different topics on different strategies, tactics, tips, or what have you. Today we're going to discuss discovery. And so this is not legal advice. We're talking about, in general, how the discovery process works, but it shouldn't be interpreted that we're giving anyone any specific legal advice. We're not attorneys. So the problem that you and I will face periodically is we will have clients that don't do what they promise to do. So they breach their agreement. Now, if you're following our plan is to always have written, executed agreements with clients. That's important because it clarifies from both parties' perspectives what the obligations are, as well as the remedies if there's an issue. So if you're using the standard access to capital template that we've provided for you on the iimfl.org white label page, we'll make some references to that as we go through. As a white label partner, you're contracting directly with your clients and they owe you, and you can decide how you want to address when they don't do what they promise to do, which may include not paying you as they promise to pay you. We've talked about before that normally you'll want to just resolve it nicely. Normally try to visit with them. If they don't respond, send them an invoice. And an invoice never should be seen as threatening. An invoice is just normal business communication. Hey, you owe me this amount of money. And if they disagree, then they can follow up with you and you can review. And maybe sometimes invoices have to be revised because there's a mistake or a misunderstanding. If the client still doesn't pay after being invoiced, then you may want to consider filing suit against the client. And so through small claims court in your local geographic area, that tends to be a fairly simple process. Or you, of course, could hand it off to a contingency only attorney that'll handle the litigation, won't charge you anything. Those costs are passed off to the client. You could also submit client files to a collection agency or sell them to a debt buyer. But our discussion today is on discovery. So this is with the assumption that you have decided, well, the client's decided not to pay you. They owe you some amount of money, either because they breached, they quit, or they received funding they didn't pay, whatever reason they owe you money. And so we're going to talk about discovery in a way that's probably different than what you've heard before, to understand how you as the creditor have rights and what you can do legally and ethically to be able to motivate people to pay you, or at least have additional information that will put you in a much better position if you actually go to court. What's important to understand is that most lawsuits that are filed never make it to court. They're almost always, I shouldn't say that, they're typically settled before they go to court. And the discovery process aids in that. That's why the legal system is set up this way, because what discovery does is it allows you to understand the opponent's perspectives, look at their data, get their information, so there's no surprises. And so that's, again, the way the court system has worked, is if you understand their defense well enough, you could either decide to drop the suit, which is unlikely in these cases because this is a breach of contract that they owe you money, but in most cases they'll realize that they're better off just paying you as they originally did. So let's get to the white paper here that we're going through. So we're doing discovery process training for white label partners. And again, this is not legal advice. We're just talking about a legal topic. So as I mentioned, unfortunately, white label partners may encounter a client or periodically clients who breach their agreement. Discovery is the vehicle in which you collect information from the party you're litigating against as you are legally entitled to certain facts, documents, and other information while preparing for trial. Discovery, in fact, is one of the most powerful tools that you, as the white label partner, possess, and it may motivate the opposing party to seek a settlement. The four most commonly used discovery techniques are, and we'll talk about each of these briefly: interrogatories, request for admissions, request for production and inspection of documents, and this is commonly just referred to as request for production, and depositions. So again, this is relevant to you as a white label partner when you have clients that have not paid you, and it's relevant to us. So on occasion we have clients that don't pay us. On occasion we have white label partners that breach on their agreement with us. So this is relevant to the creditor, in this case you. It is important to understand that the discovery process requires, I could have put this in all caps and bold. It is important to understand that the discovery process requires that the party you are litigating against to disclose all relevant facts, even those facts that damage their defense. And if they don't participate, if they don't respond to your interrogatories, if they don't respond to your request for admissions, if they don't provide the documents that you request, and we'll talk about these as we go through, if they don't participate in the deposition, they could very well go to jail. So it moves from a civil to a criminal case if the defendant, you're the plaintiff, if the defendant is not participating in this process. So just that alone helps you better understand as the creditor. We're talking about creditors' rights. People owe you, if people owe you money, you're not defenseless. And so you have rights, and if they don't comply, then not only can they lose the case, they could go to jail. And so I think a lot of people don't realize that. So now let's go ahead and go through each of these four and how it might be relevant in helping with debt collection. All right, so we're going to start with interrogatories. So interrogatories are written questions. We're going to do oral later. This is written. Interrogatories are written questions to the other parties. In other words, you're sending it to your client that hasn't paid you. They must respond to your interrogatories under penalty of perjury. So two things. They have to respond. It's not elective. They have to respond or they'll get in trouble. And they have to answer honestly, or they could go to jail for perjury. So this is official, right? This is bona fide. They have to engage and they have to respond, or they'll get in trouble in the court system. Now, how many questions that you can prepare will vary by state. Most states limit to 40 questions. So I know when I went through my paralegal program and was preparing interrogatories for different attorneys, just coming up with 20 questions is kind of exhausting because it's kind of easy to come up with a few, but you probably will want to consider asking as many questions as you can come up with, because it gives you more and more information to strengthen your case to collect the money. And also, the more questions you ask, it's probably more motivating to the other party to say, oh man, I don't want to disclose this. I don't want to answer this. I don't want to do this. Maybe I should just pay or make some sort of payment arrangement. Some questions may be very upsetting to the other party. It could be very embarrassing, and it could even scare them, but the questions must be answered. So again, we're talking about creditors' rights, that when people stiff you, they don't pay you as agreed. You have rights through the legal system. We're talking about 4 methods of discovery to gather information to strengthen your case in case you go to litigation. You actually go to trial, but in most cases, this will aid in the resolution before the trial date. In other words, people say, all right, I'll just pay you, or work out a payment arrangement. Now, again, this is not legal advice. We're talking about a legal topic, though. So we'll talk about a couple examples of interrogatory questions. So I'm not saying these are questions that you should use in your interrogatories, but let's just talk about some common ones. List. So this is what you're asking of your client that's not paid you. So let's just pretend Joseph, Joseph's one of my friends. He's one of our white label partners and top producer out of Arkansas. So we'll just pretend that Joseph hasn't paid us. So then I would send a demand to Joseph, a discovery, and I'd say, Joseph, I want you to list every credit, every lending, every funding, and every capital arrangement that you've applied for during the past 48 months, either individually or by any businesses, Joseph, that you own or you partially own. I'd like you to detail the name of the entity that you applied with and provide me the full address, phone number, and date applied, as well as the outcome of the application. Joseph, if you ever applied for an EIDL or PPP loan, include those as well. Well, why would you maybe want to consider asking this question? Well, you know that the way that the access to capital agreement is written, unless you've changed it as a white label partner, which you can, it states that they owe you a performance fee for all capital raised during the term of the contract. So the 48 months is kind of plugged in here. Most likely you would edit that to be specific to the time frame of your agreement with them. But if they're under contract and they went out and got PPP money, they owe you a performance fee on it. If during your contract they went out and got EIDL funds, they owe you a performance fee. If they went out on their own and applied at Chase or Wells Fargo or wherever, they owe you a performance fee on it. So I can tell you that clients sometimes will go outside of the agreement, they'll go apply for funding on their own, benefiting from the work that you've done for them as a technical advisor, and you're getting stiffed. You're not collecting all the money that's owed to you. So that's just one type of question that you might ask them. Another type of question is as follows, and we'll just keep role playing Joseph. Joseph, I want you to provide a detailed list of every checking account opened, closed, or maintained by yourself, Joseph, as an individual, or even as a joint account with others, as well as any business that you have ownership in during the past 48 months. And you'd probably change that time frame to be relevant to the term of your agreement. Joseph, I want you to include the name of the bank. I want you to include the account number, the routing number. I want you to include the bank address and the phone number, as well as the average balance over the past 90 days. Because there's a chance that your clients have gone out, just as we were talking about in the first paragraph, and went outside of your technical advice and applied for funding other places. So here, we're in the first paragraph, we're trying to understand where they might have applied for. And then second, you're looking for the cash flow, the deposits that would reflect that they funded from that. So that's kind of intrusive, right? But it falls within the agreement. It's rights that you have. Another example, the third and final example of an interrogatory question that you might ask a client that has breached an agreement with you is list the date or dates and method or methods, we'll use this, Joseph, that you've initiated arbitration by yourself and or on behalf of a business you own against any party. Please also, Joseph, include the status and or outcome of any listed arbitration proceeding. Well, why would you ask that? Well, you know that the standard agreement, assuming that you're using as a white label partner, the standard access to capital agreement states that the client, if they're not satisfied with the way the process is going, that they will file arbitration to resolve it. I can tell you, since we've been in business, we've never had one client file arbitration against us. I suspect that you won't face that very often either. And so what you're doing is you're building your case because you're finding out if the client has received any other funding that they owe you a performance fee on. You also probably end up knowing banking information to be able to collect a judgment, which you should win from the court. But also you're clarifying, because if your client comes to court, let's say it actually goes to court, which is unlikely. We talked about it almost always settles beforehand. But let's say that you get to court and then the client says, well, let's say Charles is one of our white label partners. Charles didn't do what he said he would do. Charles signed me up and he didn't do what he said he would do. And so then Charles would turn around, or Charles' attorney would turn around and say, oh, really? So if you feel that I, Charles, didn't perform as agreed to my agreement, did you file arbitration as you promised to do in your agreement? And the client's going to say no, or, unless they disclosed it here, which is unlikely. So what you're doing through the interrogatory is gathering information that strengthens your case. In the unlikely event that it actually does go to trial, that you know what their answers will be before you ask the question. And if they start complaining that somehow you didn't do what you were supposed to do as a white label partner with them, then you can ask, well, if you didn't feel that I did what I was supposed to have done, why didn't you do what you promised to do, which was to resolve it through arbitration? All right, so I'm going to pause for a moment. We've covered one of the 4 methods of discovery. Does anyone have any questions, comments, concerns about what we've covered so far before we move on to the next? Winston's asking a good question. So you'll need to decide, as if you have clients that breach agreements with you, Winston, and other white label partners, you'll need to decide how you want to resolve that breach. And as I mentioned, you could litigate yourself. You could have an attorney that does it for contingency only fees. You could submit them to a collection agency, or you could sell the debt to a debt buyer. Here, what we're talking about, Winston, certainly is assuming that you decide to go file the small claims suit yourself, which is a lot easier than what you would think. And then this discovery process would possibly aid you in understanding how you can get information that would increase the likelihood of a settlement and help you if it actually goes to trial. So with that being said, Winston's question is he responsible for process serving? So we've not gone through the entire legal process from beginning to end, but let's summarize. So normally first, an invoice would be sent. We've covered that. Then a demand letter. We've briefly talked about that. And then you would, if you're going to file suit, you would file suit. And you're right. Part of that is doing the paperwork with the appropriate court, which could be small claims, state court, or federal court. Most likely you do small claims court. Small claims courts in most states will go up to $20,000 now. And so most likely your claim on that individual is less than $20,000. And then what Winston got to is serving the person. So yes, you'll definitely have to work through the court system to make sure that the defendant, the person that you're suing, is properly given notice. They're served. And so you can work with your local courthouse for that if you're going to sue them. If you don't want to sue them, you can work with an attorney, sell the debt, or work through a debt buyer. Okay, so we've covered the first of the 4 types of discoveries, which is which is interrogatories. And I think how I believe that you can see from this how it could be motivating to the defendant, the person that you're suing, the person that breached the agreement, that if they get 40 questions that ask them a bunch of information that they have to answer, or they will probably lose the case and they'll probably be held in contempt of court, which means they go to jail. That's a pain in the ass, right? So it's not meant to be unfair to them, but if they breached your agreement, you have the right for discovery, and interrogatory is the first of 4 types. Now it's going to get better. We're going to keep going, but that's the first of the 4 types. All right, so thanks for the feedback, Renee. Thanks for the question, Winston, and we'll move forward then to the second type of discovery. The second type of discovery is called a request for admissions. Request for admissions force. So it's not optional. Nothing that we're talking about today is optional. If that person has breached an agreement with you, you have creditors' rights, and we're going through those. And the defendants, the person that breached the agreement, in this example, the person that owes you money, they don't have the option to just not answer. Because if they don't answer, there's negative ramifications. All right, so request for admission, force the opposing party to commit to a position on a set of facts. The person you're litigating must admit to damaging information. So again, it's not like they can just say, oh, I don't really want to answer that question. And so we'll go through some sample questions. So again, this is not legal advice. We're not telling you what to do. We're not giving you a list of the interrogatories or requests for admissions to use. We're just having a high-level discussion. So what are some examples that you could give them? What are some questions of admissions? So the first one would be, for instance, we'll again role play with Joseph again. Joseph, I want you to admit or deny that you entered into an agreement as a white label partner. Or if he's not a white label partner, Joseph, admit or deny that you enrolled in the Access to Capital program. So, you know, what's, again, just role playing. Joseph, what's Joseph going to do? Either he did or he didn't. He has to say yes or no. He can't get into a but. It's either he did or not. Obviously, if he didn't, you shouldn't be suing him for whatever you're suing him for. So assuming that that's not the case, then he did enter into whatever agreement. And so you're just forcing a yes. Now, if Joseph lies and says no, guess what happens? He's under oath. He's committing perjury. So Joseph would, in this example, would have to say, yeah, I did sign up as a white label partner, or if it was about access to capital. I know that seems rather elementary, but you're creating leverage by putting together a set of facts that the defendant, the person that owes you money, is agreeing to under oath. And it's not uncommon that after they've gone through, and we'll go through some more examples, that they come to the conclusion of, oh shit, I mean, I owe this money, right? I owe this money, and I might as well pay this money rather than incur more cost and more pain. Okay, so these admissions can get rather aggressive. So this is not for children. So if there are any minors on this Zoom, I ask that you step aside for a few minutes. Okay, admit or deny that you've ever failed to report earned income as required by the IRS. Admit or deny that you have ever listed a false or inaccurate expense on your tax return. Joseph, admit or deny that you've ever lied on an application of any type. Joseph, admit or deny that you've ever committed any illegal act. Joseph, admit or deny that you currently are or ever have ran a criminal enterprise, including but not limited to human trafficking, drug production, sales, or child pornography. Joseph, admit or deny that you've ever used illegal drugs. Joseph, admit or deny that you've ever had an extramarital affair. Joseph, admit or deny that you've ever viewed pornography. So you can go through and create a list of questions that the client has to admit or deny. It's not looking for an explanation. It's a list of questions answered by force of the court under oath, whereby it often will position you to have a stronger likelihood that the defendant will settle, sometimes just because they don't want to answer the questions. All right, so we've covered request for admissions. Before I move on to request for production, let me scroll up a bit. What questions does anyone have on requests for admissions? And Timothy, you're right. You'll need to go through your local court to determine how many admission questions you can ask. When I went through the paralegal program and worked with attorneys, we would typically ask 20 requests for admissions. Now, here's what's really interesting. And this this is not going to make you happy. This is going to be uncomfortable, but this is the way that the rule of law works. So let's say that I sent Joseph these questions, these requests for admissions. Probably would be more, and that they'd be more relevant to whatever breach I had with Joseph. Guess what happens if Joseph doesn't answer? If you had to just guess what would happen if Joseph didn't answer these questions, does it all go away? Does life get better? Actually, what the court would say is that he has just admitted to every one of these. So that's why you word these questions where the default answer is yes. So if you serve someone and they didn't answer, then the answer would be, yes, I did enter. Yes, I failed to report income. Yes, I've listed false and inaccurate documents on my tax return. Yes, I've lied on applications. Yes, I've done illegal acts. Yes, I've ran a criminal enterprise. Yes, I've used illegal drugs. Yes, I've had affairs. Yes, I've viewed pornography. So that's the way that the admission works. So people, if you ever get an admission, this type of, if you're participating in this interrogatory, you want to answer. Because if you don't answer, then the plaintiff can submit to the court that all the answers must be yes, because they didn't answer. They didn't say no. They didn't deny anything. Oh my gosh, you can imagine how damaging that is to the defense. All right, so that's the requests for admission. So we're going through discovery, and we've talked about two of them. And so what we're learning about is that we as creditors have rights. When you have people that don't, when they breach your agreement, they don't pay you as they promised to pay you, then you can go through the litigation process. That's the way our legal system works. And what a lot of people don't realize, it's not just, oh, I just went down to the courthouse and filed suit against, in this case, example, Joseph. No, in fact, I filed suit, but now I'm going to use these different discovery techniques to gather more information to strengthen my case if it goes to trial. And the defense, in this case, Joseph, may say, oh my gosh, I don't want to answer all these questions. I don't want to have to get this deep. Let me just make this go away. Okay, so now we're on to the third type of discovery. The third type of discovery is very, very powerful, very, very powerful. And again, it's technically called request for production and inspection of documents, but it's normally just referred to as a request for production. And so this gives you not just yes or no or admit or deny answers. It doesn't give you just written responses, but now we literally have documents from them. So again, and Joseph's a great guy, but I'm just role playing with Joseph throughout. So this is where you could go ask for documents, photographs, reports, and other materials. Does not require a subpoena. And so then I could go to Joseph and ask for his contracts, his corporate records, his income tax records over the past 10 years, his bank statements over the past 10 years, any activity reports, because maybe he's been using PayPal, Venmo, Cash App, what have you. He can request emails, and we'll get more into that in a moment. I can request his text records, his client records, because he's a, well, if we had a white label partner that defaulted, then some of this would be more helpful, like understanding their client records and even phone records. So what a kick in the butt to try to produce all of this request for production. It is freaking painful. Do you think that any of the clients that have defaulted on you want to provide all of this information? Do you think they want to go through and do all of this work to gather all this information? Because again, it's not optional. They don't have the choice to say, oh no, I don't really want to provide my bank statements. No, I don't really want to provide my Venmo information because I've not reported that income on my taxes. They don't want to provide that. All right, now there's a specific type of a subpoena. And of course, it's in Latin, which I don't pronounce Latin well, but subpoena ducis tecum Demands the appearance of an individual. So what this means is that you could either request these documents through discovery, or you could request these documents and that the person hand deliver them to you, to the courthouse to review. Now, we're not getting into jurisdiction here, but where the court proceeding occurs should be detailed out in the agreement. The standard access to capital agreement allows you to go in there, that white label partners use, and put in the jurisdiction that you want to use. Normally it's near you. So if you have a client in Hawaii, but you're in Vermont, they're coming to Vermont for submitting these documents. Inconvenient. All right, so it is important to know that you can determine the production requirements. And this is another area that a lot of people are not aware of. So you might say, well, okay, I'm going to ask, let's say we had a white label partner that didn't comply. Unlikely, but let's just say that. And so we ask them for their emails. So does that mean that they just go through and print off each of their emails? Well, if you don't specify how you want the documents delivered to you, then yes. But what you'll actually do is be a bit more sophisticated than that. So for example, you can request hard copy documents and state that they should be stored in hard copy in the ordinary course of business and must be scanned and submitted as either one page or one multi-page PDF per document, or as 300 DPI single page TIFFs with corresponding document level OCR text and logical document determination in an accompanying load file. I had trouble even saying that. Can you imagine doing that? Can you imagine being subpoenaed to have to provide lots of emails that would be needing to be submitted in a very specific way, or hard copy documents? And then it gets into metadata production. And so you could state a requirement that for each document submitted electronically, include the standard metadata fields listed below in standard delimited data load file with field separations of ASCII character 20, quote characters of ASCII character 254, and multi-entry delimiters of ASCII character 174. I don't even know what half of that means, to be quite frankly, but you know what happens if the person that breached the contract against you doesn't provide the data that you requested in the way that you've requested it? It's contempt of court, and they could they'll lose the case most likely, and they may go to jail. So again, what are we going through? We don't want to make people's life difficult, but I think we have to protect ourselves from being taken advantage of. People will sign contracts with you. Sometimes they'll dismiss them like, oh, that doesn't apply to me, or my credit's already shitty, I don't care, or I don't have any money, I don't care. Well, no, you signed an agreement. Both parties need to do what they promised to do, and you have creditors' rights. And we're talking about the 4 types of discovery. The one that we're on right now is request for production. What questions or comments do any of you have on request for production before we hit the 4th and final type of discovery for today? It's a pain in the butt, right? I mean, it could take literally hundreds of hours of time, for a client that's defaulted on their agreement with you to get everything packaged up in the requested way for your discovery request. Why would they want to do that? Why wouldn't they just do what they promised to do in the agreement? Or if they don't do it, promise to pay you as they promised to pay you? Why in the world do we have to go through all these damn hoops and jump and dance and parade around when all we're asking people to do is to fulfill the promises that they made? All right, any questions on request for production? Okay, we'll wrap it up here. So the last and the 4th type of discovery are depositions. And this is just a 1 paragraph, so it's simple. So depositions are the oral questions posed to a witness under oath. So again, throughout this, The person that has cheated you, the person that has not paid you as agreed, the person that's breached the agreement, they don't have the option to do this or not if you ask for it properly. They cannot lie because all of this is at risk of perjury because it's under oath. So the oral questions also are under oath. In most cases, the deposition, our depositions are all held here because that's the way our agreement's written. You will determine in your agreement where the court cases are filed and where the depositions could occur. Most likely it's in your county. And there's a court reporter. This is yet another expense. Can you imagine? And again, I'm just role playing Joseph because we've been doing that throughout the call today. But let's say Joseph owes us some money, and we go file suit against him, and we go through the discovery process of all 4 types of discovery. And we also let Joseph know, all right, Joseph, we're going to set up depositions. It's going to be in Wood County 2 weeks from today. And we need to make sure that you're here. It's got to be done in person. And by the way, we're going to need a court reporter. It's required. And Joseph, you're going to pay for that court reporter. You know that, right? So now Joseph's got to fly in or drive in, time, and he's freaking paying for the court reporter. So obviously you have rights as the creditor. You don't have to be the victim. When people try to screw you and don't pay you as agreed, you have rights. And again, as we mentioned, since the deposition testimony is given under oath, if they lie, it's perjury. They go to jail. So in summary, we can make this a little bit smaller. Our goal today is not to give legal advice, but just to increase awareness that if people owe you money, you have rights. It's called creditor's rights. And if you decide to litigate, one of the most powerful elements of preparing your case, which often will result in an early settlement to your benefit, is the discovery process. The discovery process has 4 techniques that are commonly used: interrogatories, which are written, open-ended questions; request for admissions, more of yes or no, technically admit or deny; request for productions, where they're providing you hard copies or electronic information, including text records, phone records, emails; and then depositions, where they sit down in front of a court reporter under oath and answer more questions. So I think you can see that you have a lot more control than maybe what you thought. As a white label partner, we want to do what we promise to do for clients. If the client doesn't do what they promise to do, you have creditor's rights, and the discovery process is a powerful tool to gather the data to possibly encourage an early settlement, or certainly to strengthen your case in trial. Okay, so who has questions on what we've covered today with the discovery process for white label partners? Was this useful? Was this a waste of your time? Was this new information that you weren't aware of? So looking for your feedback, comments, concerns in the Q&A box. It's kind of like the chat box of Zoom. So looking for feedback. Al, what do you think? Andre, Antoine, April, Beatrice, Bernard, Charles, other Charles, Devin, Elizabeth, Felicia, James, Joseph, Lee, Magnus, Mr. Rich, Marcelo, Mark, Pauline, Pierre. Well, Pierre just responded. Thank you, Pierre. Renee, Samuel, Terry, Wayne, Winston, others. I only got the first 30 or so listed on my screen, but what questions do you have? So does this put the burden on you? No, you may very well want to use an attorney to handle the litigation, but this maybe opens your eyes a bit more on tools and techniques that your attorney could use on your behalf to encourage the likelihood of settlement, which is the goal. We don't want to go to trial. Trial uses the court's time and incurs more cost. And who's going to end up paying that cost? The defendant, the person that screwed you out of the money, the person that breached the agreement is going to end up paying you what they already owe you, plus they're going to cover the court cost and all these other fees. It's craziness. We don't want that. But the problem is, just like you and I deal often with financial illiteracy, often we have clients that are not aware of how things work. And that's why we focus on financial literacy. We go through the 4 modules to help them better understand how do you position yourself to be credible enough, to be fundable enough to get capital. A lot of people aren't knowledgeable about the legal system. And because of that, they think, oh, I don't care, because maybe their credit's not so good, their income's not so good, or what have you. And it's like, I don't care, what are you going to do to me? Well, what you could do, not doing to them, but just protecting your rights, is you could aggressively use these 4 different discovery techniques. And it's now an inconvenience, but it's a mandatory inconvenience, right? Because it's not optional. They have to do these things. I suspect that if you took an aggressive approach to discovery, then I suspect that many of the people would say, oh shit, I don't want to have to answer all these questions. Some of them I'd rather people not know. I don't want to have to admit or deny a bunch of things that could be embarrassing. I don't want to have to gather up and provide all this information that you're asking for in the specific format that you're requesting it. And I don't want to have to drag my ass to Wood County, Texas, or wherever you're at for oral depositions. Now, if they feel that they don't owe the money, then they should stick to their guns, right? Because this is not about taking advantage or strong-arming people. This is simply protecting your rights. You wouldn't want to go through this if they didn't have an agreement with you that they breached, right? This is not taking advantage of anyone, but there's nothing wrong with protecting your rights and frankly holding people accountable to do what they promised to do. In the end, do you want them to have to come to deposition? Of course not. Do you want them to gather all their personal information up, answer all these questions? Of course not. All you want them to do is what they promised to do when they signed the damn access to capital agreement, or if they're a white label partner, when they sign the white label partnership agreement. Just do what you promised to do. Just do what you promised to do. All right, so Leah's, I think, got the final question here, and then we'll wrap it up. Lee asks, after a person pays the full amount owed through the legal process, if he comes back and says he wants to continue the process. So that's a good point. So you'll want to go back and look at your agreement. The way that the agreement is written is if your client is not paying as agreed, then that relieves you of providing additional services, which makes sense, right? That they're not paying their bill, so why would you keep working for free? I think it would be up to you and them at the end if they paid the full amount owed, because, you know, what do they owe you? Let's wrap up on this. So if someone signs up as an access to capital client, they're promising to pay the $2,500 refundable deposit, but we don't charge them that up front, right? We help them get financing. We have guaranteed financing no matter their credit or income circumstances. And then they promise to work with you to raise at least $100,000, and they promise to pay you the performance fee off of that capital raise. Normally it's 10% of $100,000. So altogether, they're promising to pay you $12,500. I will tell you that it's going to be very commonly if you start to litigate and you get to discovery and they start getting all these requirements, they're going to be ready to settle. I suspect 95% of people, almost all of them, will say they'll tap out. No more, no more, no more, because they won't want to go through all of this. They would rather just resolve it. So often what will happen is you'll come off of the full amount owed. So let's say they owe you $12,500. It's very likely that you would negotiate a payment plan with them because they may not have $12,500, or they might offer a settlement. Hey, Lee, if I pay you $7,250 today, can we make all this go away? And so there'd be a settlement agreement. most likely, if there's a settlement agreement, that settlement agreement will then satisfy the contract and will end the relationship. But that's between you and them. So if after they paid you, if you wanted to continue to work with them, you certainly could, but there might be some ill feelings at that point. Okay, so I think we covered what I wanted to today. I hope it was helpful. And again, it's not about you being a bully or you taking advantage of people. It's just simply understanding that you have creditors' rights. And if people breach agreements against you, and we're getting ready to go through this. So we have worked with a team of over 20 attorneys and paralegals to put our model together. We have demand letters going out. We spent over $1,000, closer to $2,000 in the past week, just sending out demand letters. So the demand letters are going out. We'll give folks 30 days, and then we're going to start filing suits. And so as we file suit, we will include the request for discovery with the filing of the suit. So from day one, they're going to know, they're going to get served, and they're going to know, here are the interrogatories that we need from you. Here are the requests for admissions. Here are the requests for production. And the depositions won't be set up that early, but these others will be part of that initial servicing. So they know from the get-go, hey, we need to either resolve this and make it go away consistent with the agreement that we've signed, or get prepared for a long journey. All right, well, thanks everyone. We'll see you back tomorrow morning, and I appreciate your feedback and your participation today. Have a good day. Bye-bye.